Cook.
Thank you. Well, I intend to address you on the grounds of appeal in the same order as my learned friend did.
That would be very helpful, actually. We were going to ask you to do that, having seen that your skeleton had been developed in a certain way. It obviously helps to compare and contrast the different points, but thank you very much.
Yes, the reason for the skeleton being addressed in a separate way was to illustrate the interrelationship.
We certainly understood it, and we weren't criticising you by inviting you to take a different course. It's merely, given Mr. Shaw's setting out of his stall, it's good to have the direct comparison.
My lady, before my learned friend commences, you should have a replacement authorities bundle.
Thank you very much indeed, and thank you for getting here, Mr. Shaw.
I should also say, by way of introduction, I don't intend to address you, as it were, to my learned friend's long introductory set of submissions. I'm going to try and pick up various points during the grounds of appeal to the extent that they arise. His submission seemed to be focused on convincing this court that the outcome of the quantum trial was an unjust result. I obviously don't accept that, and it's been responded to in my skeleton argument. Suffice it to say, by very, very brief introductory comments, GBR, of course, as you'll have seen, had no trading business at the beginning when Mr. Monks was made a director, as was essentially found by the liability judge. And of course, the end result of this case is that Mr. Davies, as assignee of GBR, has been put in the position which GBR would have been in had Mr. Monks complied with rather than breached his duties. And given that there's no dispute that GBR couldn't have continued to trade beyond October 2011, in my submission that's an entirely fair result, and that anything more would not be compensation but would be to enrich Mr. Davies unjustly. And the last point I was going to make by way of brief introduction is that it's simply not the case, as my learned friend repeatedly sought to suggest, that everything that GBRK had as of the 18th of October 2011 belonged in equity to GBR. Among many other problems with that submission, it simply ignores the effect of the limitation period, and it was expressly rejected by the quantum judge. So I'm going to move over then to addressing ground A of the appeal.
Thank you.
That, of course, as the court knows, is about the scope of Mr. Monks's breaches of fiduciary duty. And in short, the court will recall that the liability judge held at paragraph 272 of his judgment, which he went to with my own friend yesterday, that Mr. Monks undertook 7 listed matters which the judge found were breaches of duty. Now, before the quantum judge, my learned friend sought to suggest that the liability judge had actually made some sort of overarching finding of liability against Mr. Monks, pursuant to what I think he calls a dishonest scheme. Now, one would search in vain for any such phrase in the liability judgment, and in my submission, the liability judge clearly made no such finding. The quantum judge considered that, together with all of the other paragraphs cited, which my learned friend took you to, and which referred back to paragraph 272, that what the liability judge had done was only to make findings of breach of duty in respect of those matters. And it's worth just briefly turning up what the quantum judge did in his judgment, which is in bundle 1, tab 17 at page 246. And the reason I'm taking you to this is what you get from this is what the quantum judge thought was significant in terms of the phrases and the words used by the liability judge, because he indicates his emphasis in bold type, so you can see the thought process. And just starting at paragraph 33, one gets the paragraph 272 is quoted there, and one of the things the quantum judge felt was that the word include related back to a number of points rather than the phrase of what Mr. Monks did.
Mr. Cook, I'm terribly sorry. I seem to have gotten the muddle about where you're asking us to look.
Oh, I'm so sorry.
It's my fault entirely.
246.
Or is that paragraph or page?
It's page, paragraph 33.
Oh, sorry, that's under my nose. Yes, thank you. Sorry. Yeah.
So you'll see that the quantum judge highlighted the whole of that sentence, and there was a debate between my learned friend and I about the meaning of they include the following.
Yes.
My learned friend's point being that include related to the words what Mr. Monks did, and my point being that include related back to a number of points are clear, and the quantum judge decided that my construction of that was right, and that's what the liability judge was saying here. And then the quantum judge goes on, you see at the foot of page 246, to emphasise, this is his emphasis in bold, the way in which the liability judge relates things back to the steps that are found in 242. And he does that at 273 and 274. And then over the page, at the foot of the page, obviously 247, you've got his quotation of paragraph 275 of the liability judgment, and again it relates to the steps identified above. The next paragraph that the quantum judge quotes from appears at page 249, a few pages further on. And one sees paragraph 38 at the top of the page in relation to the allegation that Mr. Monks has breached his duty under section 172 of the Act. And then you see that I'm quoting and emphasising there the liability judge going back to those matters there. And the next reference is over the page at page 250. You see similar sorts of phrases that have been emphasised by the quantum judge that the liability judge used, and likewise at paragraph 44 as well. And then, importantly in my submission, going over to page 252, so a couple of pages further over, at the foot of the page, the quantum judge quotes from paragraph 395. And this was in the context of my learned friend's argument that effectively the deeming effect of the provision in the Companies Act had the effect of, as it were, constituting Mr. Monks in breach of duty for the entire period of dissolution. And what the liability judge said was, for those reasons, I'm not persuaded by Mr. Davies' argument that Mr. Monks and Mr. Ford were and are subject to continuing duties even today by means of the deeming provision. Consequently, I do not consider the question of what remedy follows from the breaches of duties I have identified can be answered as easily as Mr. Davies would perhaps wish, by saying that the whole of GBRK's current business is held on constructive trust. So, in my submission, it's clear that the liability judge understood what the role of the quantum hearing was going to be, which was to see what the remedy flowed from the breaches of duty that he had identified. And the only breaches of duty, plainly in my submission, that he identified were those which you see in paragraph 272. And so that, as it were, is the construction question that my learned friend referred to in the course of his submissions yesterday. And I would respectfully adopt the formulation by my Lady Justice Macur, which is that this court would have to think that the judge had adopted an unreasonable construction of the liability judgment. And in my submission, he was plainly right to adopt the construction that he did for essentially the reasons that he gave.
Why do we have to be satisfied it's unreasonable? Surely it's just a question of construction, it's right or wrong.
Well, I adopt the position that my lady took yesterday. I think it doesn't make any difference ultimately which approach you take, whether you look at it de novo or you look at it from a reasonable standpoint. In my submission, it's perfectly clear what the meaning of the judgment is, and would invite you to reach that conclusion, even looking at it entirely afresh.
Why did he say including?
Well, he says including because he's talking about a number of points being clear. You've got to remember the context in which paragraph 272 was drafted. The judge had basically said that this situation is a mess. I'm doing the best I can with the fragmented evidential picture I've got before me, and these are the points that I feel I'm able to make findings on, because these are the points that are clear. So, yeah. In my submission, that's how you explain it. But there's really no other way to look at it if you look at the rest of the judgment. I mean, in a sense, it's not just about that particular phrase. One has to ask the question, what other findings were actually made of breach in this case?
Well, that's undoubtedly so, in a sense. Those are the findings that the liability judge made, and unsurprisingly, he then refers back to them on frequent occasions. But does that necessarily mean he was ruling out the possibility at the quantum trial of further evidence being adduced, which might lead to the quantum judge reaching further findings of breach, obviously which don't conflict with the findings the liability judge has already made, but might extend them?
Well, in my submission, he was. I mean, I'm going to come on to address the division of labour, which is my lady Justice Asplin's point of yesterday. But just in terms of my learned friend's point, in terms of how he puts his case on this appeal, I was just going to take you to what he said in his skeleton argument for this appeal, because it seemed during the course of his submissions yesterday that he was focusing on the construction question, which we've been discussing. But if I could just take you to paragraph 34 of his skeleton, which is in volume 1, tab 5, page 31. Sorry, yes, paragraph 34, page 31.
Yes.
Accordingly, while Mr. Holland was correct to conclude at paragraph 78 of the quantum judgment that Mr. Johnson limited his ruling on Mr. Monk's breaches of duty to 7 matters in 272. So just pausing there, I mean, it rather seems to me from reading the skeleton that he was conceding that the construction was correct, but he was making my lord's point, effectively, about what should have happened at the quantum trial. It's a little bit confusing because it seemed to me during the course of my learned friend's oral submissions that he was rather going back to the construction question, but I'd understood his case on this appeal to be different. I mean, my submission's going to be that neither is correct, but I just thought I'd draw that to your attention. And what he goes on to say is at paragraph 47, this is page 33 over the page. For these reasons, Mr. Holland ought to have concluded that all steps undertaken by Mr. Monks in further of his dishonest scheme constituted breaches of duty prior to the dissolution of GBR on 18th of October 2011.
Sorry, could you give me the paragraph?
Oh, I'm so sorry. It's paragraph 47.
47, yeah.
Page 33.
Yeah, thank you. Yesterday I asked Mr. Shaw whether or not he'd or anybody had called any further evidence regarding matters that contextualised paragraph 272, and he said no, and that the reason that he didn't have to was because he'd established by the findings the remedy of account. That's
Yes.
what he said. Now, obviously, you're taking us to different parts of the skeleton which don't support that submission.
No.
But in answer to my lord, you said that you did not interpret 272 to mean, and for the moment I presume that you also include the interaction between counsel and the quantum, forgive me, the liability judge, prior to the order being drawn, that you didn't think that it invited any further evidence before the quantum judge. But whether it did or it didn't, do you agree that there was no further evidence that would entitle the quantum judge to make further findings beyond those 7?
Yes, I very much do say that. There are a number of points to be made along the way. I mean,
I'm sorry if
yes,
I'm
no, absolutely. I divide
ahead.
these into sort of, as it were, legal points, and then there's practical points. I'm going to come on to the practical points, one of which is no evidence, no invitation to the quantum judge to make the relevant findings. But I'm getting slightly ahead of myself. I'll come on to that. I mean, I certainly do say that.
So whatever the quantum, forgive me, whatever the construction made, you say that there was nothing there for the quantum judge to bite on.
Yes, I maybe put it this way. The quantum judge can't be criticised for not having made those findings in the circumstances.
You've taken us to paragraph 47, where Mr. Shaw argues that the quantum judge ought to have concluded that all steps undertaken by Mr. Monks in furtherance of his dishonest scheme constituted breaches of duty. But that seems to be on the basis of the evidence that was already before the liability judge, if no further evidence was called.
Well, it would have to be.
Yeah, okay. All right, well, Mr. Shaw can
Yes.
pick that up if he feels it appropriate in response.
Yeah, so to slightly sum up, if my learned friend is just saying it's a question of construction of the liability judgment, then essentially I say the judge was right for the reasons he gave, and which seems to be common ground if one looks at that paragraph of the skeleton argument. If he's saying instead that the liability judgment did not contain all the findings of liability, and that it was incumbent on Mr. Holland to make further findings, then such an outcome would also have been wrong, in my submission, for at least 3 reasons. Now, the first is that the liability judge was tasked with determining which breaches of duty had taken place, and that's precisely what he did. I'm going to take you to the order that was made by Master Clerk that split the trial into one of liability and quantum, and we can take this up in volume 2 at tab 28. It's page 116 of volume 2.
116.
116, page 116.
I think that's tab 27 then.
Yeah.
I'm so sorry.
Yeah.
Could I just ask, is it more helpful to the court to just give the page number, or would you like the tab?
Tabs are helpful to me anyway, thank you.
Yeah. But perhaps if you can give both, since
I'll
there's obviously
try.
a bit of
Yeah.
discordance.
Page 116, this is, as it were, one of the first CMCs that took place in this matter. And one gets at paragraph 3, a split trial of liability and quantum issues to take place, to be listed on the following basis. And then over the page, it's not as interesting as you might have thought. It just has a sort of effectively a timetable, or a proposed timetable. I'm coming to where the issues are delineated. So that was an order that was on in December 2018, and then going forward in time to subsequent CMC, page 122, sorry, tab 28. Forgive me, the first page of the order is on page 121, but then the relevant bit for our purposes is at the bottom of 122, paragraph 7. The following are the issues that arise for determination at the liability trial. And then one sees at page 123 whether the second defendant has acted in breach of duty or in breach of contract. And again, I don't think it's necessary for me to take you to it, but it was well understood by the liability judge that that was what his role was. Because at paragraph 9 of his judgment, he describes the case as being a split trial. He uses the phrase, I think, the word bifurcated, to suggest that obviously there was this distinction between liability and quantum. In my submission, the effect of that order was that all issues of liability would be determined by the liability judge. And pausing there, it's obvious why this must be. If there were going to be additional findings of liability made at a later stage, when were they going to be quantified? And in practice, how would the quantum trial work? What target did we, as the defendants, have to hit? Now, when pressed by my Lady Justice Asplin about what the division of labour was between the liability and quantum judge, my learned friend said that the liability judge just had to determine that Mr. Monks acted in dishonest breach of duty, and therefore he was susceptible to an account, he said. Well, in my submission, that's clearly not correct. We'll come on to look at the order that was made. In fact, we looked at it yesterday. But it was not for an account. It was for liability against Mr. Monks, for equitable compensation. So my learned friend had made his election as to the remedy, the equitable remedy he was going to seek against Mr. Monks. And it was for liability in knowing receipt against GBRK. That was the order that was made as a result of the liability trial. So it manifestly was not an account. My learned friend graphically referred yesterday to the Chancery Master with his quill. That was manifestly not what the quantum judgment was going to be dealing with. The next point is that my learned friend seeks to place reliance on the manner in which the liability order was formulated. And I don't think it's necessary to go back to it. We looked at it yesterday, the part of the transcript where I was saying that I was inviting the judge, as it were, to use a different form of words for the order. And effectively, the judge didn't take up that suggestion and said, well, look, effectively, it doesn't matter. You've got to look at that in the context of my judgment. So that's what he said. And clearly, that is the way in which the order needs to then be construed. And as my lord observed yesterday, that of itself doesn't support my learned friend's suggestion that the scope of liability was somehow wider as a result. One comes back again, unfortunately, to the terms of the judgment. And so I do say that if Mr. Davies considered that the liability judge's ruling was incomplete or incorrect, he should have appealed. And my learned friend said, well, what do I appeal? The answer to that in my submission is that he should appeal the order once it became clear that the liability judge had indicated that his order was to be read in the light of his judgment.
After all, we're always being told appeals lie against orders rather than reasons.
Well, that's true, but clearly if the order is to be understood in that manner, I mean, either my learned friend considered he was right as a matter of construction of that judgment, in which case he'd take his chances at the quantum trial, or he didn't, in which case he should have appealed it. But either way, in my submission, what he can't do is just leave the position and then ask the quantum judge, or say to the quantum judge, well, I want more findings on liability. My second point is that one has to look at it from the perspective of the quantum judge on a practical level. Mr. Davies didn't specify what Mr. Monk's other breaches of duty were supposed to have been, nor, as he said during the course of his submissions yesterday, did he actually invite the quantum judge to make any further findings of liability. And I say parenthetically, that's no doubt because his position before the quantum judge was that the liability judge had already made the findings. Nor, as we were just discussing, and as he accepted in response to a question from the court, did he lead any additional evidence to support any such findings. So, in my submission, there's simply no basis for criticising the quantum judge for not having made them. The third point I want to make was about how this ground fits into the relief that the quantum judge actually granted. Taking first equitable compensation, the court knows that the judge ordered compensation to give GBR the value of GBRK's business as at the 18th of October 2011, on the footing that Mr. Monks had acted in accordance with his duties to GBR. But the key point here, of course, is that the judge didn't seek to do that by reference to the individual breaches that you see at paragraph 272 of the liability judgment. He did this by reference to the value of GBRK, which was treated as a proxy for GBR, or the position, or the world, in a world where Mr. Monks complied with his duties, the position that GBR would have been in. Sorry, yeah. Even assuming any further findings of breach could conceivably or conceptually have been made, they would have been reflected in the value of GBRK in any event. So it's impossible to see what any other alleged breaches would have added to that measure of compensation. Next, turning to knowing receipts.
Sorry, could you just hold on for a second while I make a rather slow note?
Indeed. Forgive me.
Yeah, thank you.
Turning next to knowing receipts. Of course, it should be noted that the claim against GBRK had to relate to knowing receipt in the second period. Just to remind the court, that means the 5 months between May 2011 and October 2011. And the reason for that is that the claim in respect of the first period was, of course, time barred as against GBRK because it wasn't a fiduciary. And Mr. Monks didn't commit any further breaches of duty after the end of the second period because GBR was dissolved at that point. So there is this narrow pathway, which is the second period. And none of the breaches in paragraph 272 of the liability judgment occurred during the second period, except for the lease of the Ashford site, which Mr. Monks took out in his own name. Now that, of course, forms its own ground of appeal in this appeal as ground D. So, in conclusion, firstly, it's unclear whether my learned friend pursues his criticism of the quantum judge for not having made further findings of liability, but if he does, in my submission, it's unjustified. It was far too late for the making of any further such findings. Secondly, even if further findings had been made, they would have made no impact on the ultimate remedy. And thirdly, sort of conversely, this ground is actually necessary but not sufficient in respect of several other of Mr. Davies' grounds of appeal, namely B, C, D and E. And the position is that unless he succeeds on this ground, firstly ground B falls away. Ground B, just to remind the court, concerns whether you can knowingly receive an opportunity. And that falls away because the liability judge didn't find any opportunities which were received in the second period. So all the opportunities that, all arguable opportunities that took place, for example, the waste management licence, the O licence and all that sort of thing, they all occurred during the first period on the liability judge's findings. And so that's ground B. Ground C, which you'll recall is about the 21,000 withdrawn from GBR's bank account. Well, that in my submission falls away because there was no finding of liability in respect of the 21,000, aside, of course, from all the other problems with these grounds of appeal. And ground D, which is the claim for the Ashford site, that falls away because while Mr. Monks was found to have breached his duties by taking out a lease in the second period, that lease was in his name and not in the name of GBRK's. So it simply can't be the subject of any claim in knowing receipt. And finally, ground E, which concerns the judge's refusal to order an account of profits against GBRK. That falls away because there's no knowing receipt. And even if I think even my learned friend accepts that if he fails on ground A and B, he can't realistically succeed on overturning the judge's discretionary refusal to grant an account of profits against GBRK, which is in ground E. So, my ladies, my lord, unless there are any further questions on ground A, that was all I was proposing to say for now. I'm going to turn then to ground B, which concerns the claim against GBRK in knowing receipt. Now, as you heard yesterday, my learned friend argues that the judge was wrong to conclude that GBRK's liability in knowing receipt required it to have received pre-existing trust property. Instead, what he argues is that GBRK's liability in knowing receipt should have been extended to, and I'm quoting, everything received by GBRK in breach of Mr. Monks's and Mr. Ford's duties as directors of GBR. And this, he says, leads to the result that the entirety of GBRK's business was held beneficially for GBR. Now, in my submission, that's incorrect for essentially the reasons that the judge gave, who analysed the authorities correctly at paragraphs 236 to 249 of his judgment, and we'll go to those in a second. But before we look at the judgment, I just want to highlight that the basic problem with Mr. Davies' position is that for a claim in knowing receipt to succeed against GBRK, it needs to receive property in which Mr. Davies, as an assignee of GBR, asserts a proprietary interest. And the short point is one simply can't have a proprietary interest in an opportunity. Now, I'm just going to take you then to the judgment, which goes through some of the authorities. And I think
just a moment again, please.
And in relation to that, therefore, Mr. Cook, you say that doesn't work for knowing receipt by the third party,
yes.
But making use of opportunities, if you are not the third party, you are the trustee, is obviously a breach of your trust for which you will be liable one way or another.
Yes.
But that's the difference.
That is the difference, and it is a very important difference, and the law is very clear on that. So I'm just going to go to the judgment, and I would like to take the court obviously through the authorities itself, but I think the quickest way to do it by reference to the key passages is by reference to what the quantum judge dealt with. So could I invite the court to turn up page 333 of bundle 1?
Yes. And as a general comment, the quantum judge did deal very fully and carefully with the authorities in his judgment, no doubt perfecting the very full and careful sufficiency he had on both sides.
I certainly took him through all of the authorities. So it's page 333 of bundle 1, tab 17. It's the heading entitled Discussion before paragraph 236. And this is really the analysis. I mean, the quantum judge summarised effectively the argument my own friend and I made in the preceding paragraphs.
Yes.
And he then, as it were, takes up his own analysis of the authorities. That we can skip over 333, which is an introductory paragraph, and then one gets over the page at page 334. Paragraph 237, he cites the well-known formulation of the principles by Lord Justice Hoffman, as he then was, in Elajou. For this purpose, the plaintiff must show, first, disposal of his assets in breach of fiduciary duty. Secondly, the beneficial receipt by the defendant of assets which are traceable as representing the assets of the plaintiff. And thirdly, knowledge on the part of the defendant that the assets are traceable to a breach of fiduciary duty. And then further down, the judge adds his comments based on the case of Brown and Bennett, in which the Court of Appeal stressed that receipt must be the direct consequence of the alleged breach of trust or fiduciary duty for which the recipient is said to have notice. And then further on, paragraph 238, the judge cites the Courtwood Holdings case, in which it was held as follows: in my judgment, the ratio of Brown and Bennett is that it is a prerequisite of a claim in knowing receipt. The disposition to the recipient is in breach of trust. That is, that the disposition is itself a breach of trust or breach of fiduciary duty. It is not enough that the disposition follows or is caused by other breaches of trust or fiduciary duty. And I just pause there, I mean, to note that quotation from Courtwood, because that's going to be important later when we're considering ground D, which is about the Ashford site. Because of course the transfer to the knowing recipient has to itself be a breach of trust. And again, the short point there is that the transfers that took place in 2016 were long after GBR had been resolved, so there couldn't have been a breach of trust because there was no duties owed by Mr. Monks at that stage. But we'll come on to that in due course. Moving on then to over the page, page 335, paragraph 240. The judge discusses the case of criterion properties. And then, but rather than me reading it out, if I could just invite the court just to read the quotation there, and the judge's further analysis of it about halfway down the page.
And presumably you would draw an analogy between rights under an executory contract and an opportunity. I mean, that they're both sort of in the commercial sense things of value which may or may not materialise, but they don't have a status of being anything one can call an asset in which a proprietary interest can subsist.
Exactly.
Until the opportunity materialises.
Exactly. And the reason I take you to criterion properties is really because I think it's true to say I relied on the Commonwealth Oil case, the Scottish case, but the reality is, in my submission, it simply reflected the Scottish court's analysis of the English authorities. So that takes me on to paragraph 241, where he mentions that I referred him to the Scottish case of Commonwealth Oil. It's worth, I mean, the passage that the judge quotes at the bottom of the page is the key one, but it's worth dwelling just for a moment on the facts of that case. The claimant in that case was suing a third party who had entered into a memorandum of understanding with a counterparty, which was said to have been negotiated and facilitated by the first defendant in breach of his fiduciary duty. So there are, I mean, to use my learned friend's example about the sort of a diversion of customer contracts, it's a bit like what he's saying about Mr. Monk's allegedly procuring that GBRK enter into a contract in breach of duty. So in my submission, the facts of the Commonwealth Oil and Gas case are extremely closely analogous to our case. And really the answer is in the quotation by the judge at the foot of the page, and I just invite you to read that. It's 336 at the foot, and then over the page, most of the way down 337.
Would you also accept that there's nothing surprising in reaching that conclusion, because we're dealing here with a form of secondary liability on the part of somebody who is not a fiduciary?
Absolutely. That's exactly the distinction I draw. And what one sees then that the judge effectively says, well, it is Scottish authority, but it's obviously highly persuasive, and then he summarises what he interprets to be the effect of the decision, which is exactly correct and supportable. And then he goes on to cite, I mean, it's of less importance in a way, but I also relied on the High Court of Australia's decision in Barrack Instructions, which was about the status of information as a species of, or an alleged species of property capable of found in claim in known receipt, and the High Court of Australia effectively rejected that. I think my learned friend seemed to suggest that that rejection was as a result of a concession by counsel. I don't propose to take up time by taking the court to the relevant passage, but if, for the court's note, if you go back to paragraph 120 of that decision, which is at the Authorities Bundle 1, tab 30, page 702, you'll see that effectively what the judge is saying is, well, that is the position as a matter of law in Australia. But I don't place enormous weight on that. It was just another one I cited to the judge. But it's perfectly consistent with the position which I say pertains in both England and Scotland.
Can you give me that reference again?
Yes, forgive me. It's Authorities Bundle 1, tab 30, at page 702.
Thank you. And the paragraph?
Paragraph 120. My learned friend, I think he may have taken you to it yesterday.
Yeah.
Yeah.
I note also, while we're on the subject of information, the decision of the Court of Appeal in Grey and Global Horizons, which I understand that my lord sat on that panel, also dealt with this question briefly. Again, I don't propose to turn it up, but it's in Authorities Bundle 3 at tab 56 at page 2108. So again, that's Authorities Bundle 3, tab 56, page 2108. and it's paragraphs 460 to 461. And what the court said there was that an opportunity is neither a right nor an interest, but simply a description of circumstances which, if exploited, may enable a profit to be made. But fortunately, and now moving away from the judgment, all of this has been put to bed in my submission by the decision of this court in Byers. Now, of course, that was decided last year, but neither parties nor the quantum judge had the benefit of that decision for the purposes of this trial. But it turns out that the judge found it in a way which is perfectly consistent with the decision. The facts of that case, before we turn to it, are that the claimant was making a claim against a Saudi Arabian bank called Samba, as well as the Saudi National Bank, which had acquired Samba's assets and liabilities. The claimant was alleging knowing receipt of trust property in the form of shares, which are called what they call the disputed securities. And the receipt relied upon was the legal transfer of the disputed securities into Samba's name, which was alleged to be a breach of trust itself. So in Byers, there was receipt of an identified asset, namely the disputed securities, which were previously owned by Mr. Al-Sayna. Now, the problem in Byers was that, as a matter of Saudi Arabian law, upon the transfer from Mr. Al-Sayna to Samba, there was no proprietary claim or interest in the property which could be established by the claimant. And the court effectively held that the claim in knowing receipt had to fail as a result of that. And so taking up the judgment itself, that's in Authorities Bundle 3.
And just pausing there, a domestic equivalent would be if the doctrine of overreaching had applied on the transfer. Is that
Yes, I mean, if as a result of the transaction, you as the recipient obtain clean title, it's sort of another way of analysing it.
Yeah.
I think the way the court put it was it would be odd to say that you could be a knowing recipient of that property if, as a matter of law, you've obtained clean title. But it's sort of looking at it from the other end of the telescope.
Yes.
So Authorities Bundle 3, tab 58. And it's page 2134. So the first paragraph I would take you to is paragraph 18. I should just say, obviously, this is in the section that's sort of discussing the general principles. Paragraph 18, liability in knowing receipt thus derives from the combination of the beneficial receipt of assets, which are traceable as representing the assets of the plaintiff, and the recipient's state of knowledge, having been such as to make it unconscionable for him to retain the benefit of the receipt. Neither is enough on its own. While it is essential that the defendant should have received the property of another, liability is not considered to be triggered by the mere fact of receipt. There must also be unconscionability. On the other hand, dishonesty is not required. The fact that the defendant must have received relevant property makes a lesser test of fault appropriate. So what does see sort of from this that the narrow, I mean, knowing receipt is a relatively narrow form of relief. And then moving down, I think my learned friend said he anticipated I'd go to this, and I do. Paragraph 21, Mr. Chapman, who appeared for the defendants with Mr. Murray, suggested that it can suffice for liability that the defendant benefited from trust property, regardless of whether he actually received such property. The defendant could thus, Mr. Chapman submitted, be liable for knowing receipt if, say, the trustee had wrongfully spent trust money on a holiday for the defendant, albeit that none of the money ever passed through the defendant's hands. And that's rejected at paragraph 22. In our view, that is not correct. Success in a knowing receipt claim depends, as it seems to us, on establishing Hoffman's, as the summary indicates, we've been to that. The defendant must have received trust assets, not just benefited from them. And then there's a quote from the Novaship case, which we'll look at in a minute. The receipt of trust property is the gist of the action. So it's worth dwelling just for a moment on that concept because it's important to grounds C and D in my submission. The mere deliberate conferment of a benefit on somebody is not enough to found a claim in known receipt. So the paying for someone's holiday example, which is given in Byers, was expressly held not to be enough. But in my submission, paying someone else's debts or paying for their lease is likewise not enough to hold the third party liable in knowing receipt. And that's because they simply haven't received any property which the claimant can assert a beneficial interest in. Knowing receipt isn't some form of restitution claim by which a defendant is unjustly enriched. It's only about receipt of property.
So it's much more akin, really, to a sort of tracing remedy, is that fair to say? I mean, it's a way of following trust property into the hands of a third party.
Yeah, well,
maybe it's not a helpful analogy.
I mean, it's a justification for imposing upon the third party the obligations that the cause of action does, because you're saying essentially that's my property that you've received. It is the way I would interpret it, which is why I think they say it's the gist of the action. But yes, there may be some parallels. I'm somewhat reluctant. I mean, it may be there are implications of that being were that to be the analysis.
I know these are all deep and troubled waters, or can be once one can.
Yes.
So it may be safer to stick to.
I'll stick to the
straight doctrine.
Stick to the test, yeah.
But that was the way that Lord Hoffman, when he was Lord Justice Hoffman, described it, and it's quoted there in 22
Yes.
as it indicates a beneficial receipt by the defendant of assets which are traceable as representing the assets of the claimant.
Yes, and I suppose it's why you get if you provided the known recipient still got the asset, you get the constructive trust because of but
so conferment of a benefit
yes
is just not sufficient.
Not good enough. It doesn't matter how deliberate that is.
No, and it's a matter of interest. What remedy would be open to the person who'd been deprived of the money that'd been spent on a holiday or paying debts of another?
Well, I suppose the answer is it depends. I mean, it depends on the facts. There may be all manner of causes of action you might be able to assert.
But they wouldn't be left without a remedy,
no.
necessarily.
No. I'm going to come on to deal with my learned friend's submission that, as it were, this leaves the wronged beneficiary without a remedy. But no, I mean it. But I'm hesitant to. It's difficult to go into it because, in a sense, it's all just hypothetical. You'd have to look at the facts of each case.
Yeah, of course. But forgive me. One of the things Mr. Shaw said yesterday, which certainly I'd like to see how you answer, is that what the liability judge did was to find fraud, and in those circumstances, you shouldn't allow. Forgive me for the inelegant language, a fraudster to benefit by saying technically, well, this is conferment of a benefit in terms of the lease, and you're going to come on to that in Ground D, and therefore somebody in Mr. Monk's position, as he has found to be, could say, well, I'm going to set up a company, and I will make sure that everything goes to the company through me as a benefit rather than as a tangible asset. So, but perhaps there's a better time to come to that in your submissions, but I would like an answer to it.
Yeah,
or your answer, your
I will, but maybe I'll give a little answer now. I mean, my learned friend, he talks about fraud a lot, but you've got to look at, first of all, the liability judge found it was necessary for him to find whether the breaches of duty were dishonest because of the limitation point. So that was the context in which he made the findings. And he found that those breaches were dishonest in the sense that they weren't motivated by I think he put it, I don't want to misquote it, but effectively he was saying, well, they weren't motivated by a desire to, as it were, do the best you could in the circumstances. They were motivated by a desire to prefer your own interest. But
profit,
I think the idea of it, you've got to be quite careful about how we characterise the case, because just to say it's a fraud case, Mr. Monk's is a fraudster, etc., in my submission is not an accurate characterisation of what was being found. We were concerned with breaches of duty, and the question was, were they dishonest or were they sort of innocent, if you like?
Yeah.
And that's the distinction that's been drawn. So that's the first part of the answer. The second part is, of course, this is about a claim in knowing receipt against GBRK.
Yes.
And in that context, we'll come on to this, but it wasn't ever contended, and the quantum judge expressly found that wasn't what happened with GBRK. It was not treated as being a sort of alter ego or something in respect of which you could pierce the veil. So it's that sort of submission is simply not open to him.
And so your response would be, in very short forms, that if it dependent on the circumstances, if that is what had happened, there would be very, very significant grounds to say this appears the corporate veil.
Yeah, I mean, you can analyse. I mean, there are various ways. I think during the discussion yesterday with my learned friend, it was about whether it's a nominee or.
Yeah.
I mean, the law has various tools by which it can overcome difficulties that are put in place by people of that kind. I say simply isn't this case, but I wouldn't want to speculate about what could or couldn't be a remedy because it's always going to depend on the facts.
No, it was just the point made by Mr. Shaw, which I think calls for a response.
Yes.
Yeah, and that's your response.
Well, that's my response for now.
Yeah.
Maybe I respond to it more fully later on.
Okay.
And there's also this sort of, sometimes it's important not to lose sight of the big points. I mean, is it right to say the big point for me is you always have a personal remedy against the defaulting fiduciary himself?
It was going to be my first point when I came to that. And in a sense, it's only not good enough if the person isn't good for the money.
Yeah.
But before you go on, if we could go back to buyers, not that I'm taking you back and I'm not derailing you, just to point out that there is a further discussion that we recorded in buyers, which goes on in the paragraphs, for example, from 22 right through maybe into the 40s, which is about the nature of the relief and whether it's, in effect, tracing, whether it's unjust enrichment, what it is. So I'm not taking up your time now, but there is a lengthy consideration of it there.
Thank you.
Well, I'm afraid I wasn't going to take the
No,
call.
and I'm not suggesting that you should. It's just that issue came up very slightly, and I thought I ought to mention it.
Yes. I'm going to deal, just before we depart from buyers, with my learned friend's submission. I think he first submitted about buyers that all it decided was that there had to be receipt. And he said he quibbled with the notion that it required there to be pre-existing trust property. Well, in my submission, that's clearly wrong based on the passages that I've shown you. And later, I think it was in the context of Ground C, but I may as well deal with it now. He tried to distinguish buyers on the basis that he says it's different if GBRK has incurred liabilities because conferring a benefit is the equivalent of handing over cash to GBRK. Well, I'm afraid I disagree. One, again, still has to ask rhetorically, what property has actually been received in these circumstances? And if the answer is the benefit of having fewer debts, as I think it must be, then that's not property. It's really the absence of a burden. So to put it another way, one can't hold the benefit of having fewer debts on trust. So my submission that it doesn't matter how the benefits are conferred. The holiday is just an example. It's a graphic one, but it's an example nevertheless. There's another aspect of buyers which I just wanted to take you to because it's important to one of the other grounds, is that the claimant must have a continuing proprietary interest in the property. And one gets that from paragraph 69 to 70, and that's at 2147. And it's discussed at paragraph 69 to 70, and then at 79 one gets the conclusion, and I'll probably just read that one out. In short, a continuing proprietary interest in the relevant property is required for a knowing receipt claim to be possible. A defendant cannot be liable for knowing receipt if he took the property free of any interest of the claimant. This is going back to the point I was discussing with my lord. Yeah. It follows that as the judge held, absent the continuing proprietary interest in the disputed securities at the time of registration, claim in knowing receipt as pleaded will fail. So that was in that case about the Saudi law, which had been accepted by the judge to have extinguished the proprietary claim at the point of receipt.
And the same point's made in 74 as well.
Indeed, by reference to authorities that, among others, Court would. So in my submission, that really is the beginning and end of my learned friend's case on this ground of appeal. The judge was clearly right to conclude what he did, even though none of us had the benefit of that decision when we did the trial. And I also add that with buyers now the leading authority on knowing receipts, earlier cases must be treated with some caution. Nevertheless, I'll turn briefly now to the authorities that my learned friend took you to yesterday orally. I'm going to start with his favourite case, Buller and Buller. Now, perhaps it's best just to take that up. It's in Volume 1, tab 23. Sorry, Authorities Bundle, Volume 1. Tab 23. And it starts at 418. Now,
sorry, tab.
Sorry, it's tab 23, page 418.
Thank you.
Now, the first point to make is a fairly obvious one, which is that this, in my submission, is not a case about known receipt. It was an unfair prejudice petition. In other words, a petition by a shareholder of a company complaining that the affairs of the company had been conducted in an unfairly prejudicial way. And obviously, it's a slightly unusual cause of action, a unique one. The court's asked to decide whether the conduct was unfair, and if it concludes that it's unfair, it has an incredibly broad power under what was then in Buller, Section 461 of the 1985 Companies Act, now Section 996, to grant a remedy. And the wording is broad. It's to make such order as it thinks fit for giving relief in respect to the matters complained of. And so, in my submission, it was under that jurisdiction that the relief was ultimately granted. And as we discussed yesterday, the primary relief that the shareholders were seeking in Buller was that the minority sell their shares in the company to them. That was they had a whole trial about whether or not the conduct was unfair, which included examining whether or not the directors, and they were shareholder directors in that case, had acted in breach of duty. And what they wanted by way of relief was they wanted to take the company, basically. They wanted to take control of the company by buying a minority out. And His Honour Judge Berens ultimately refused that relief. What we ended up with was an order that the company transferred the property, the recipient, as it were, or the company in which there was a property, transferred it to the company in which all of the shareholders were shareholders, and that company pay effectively for or pay the purchase price that had been paid by the other company. So it was an unusual remedy, and what happened in that case was that the judge below didn't actually grant a proprietary remedy in his judgment, and forgive me for this, but I've gone back to Buller at first instance, which isn't actually in the authorities bundle, but I think it's worth looking at what happened below. I don't know if the court received an email this morning containing that. I'm so sorry. Would it be possible to hand up? My learned friend, I should hasten to add, has had this together with the email from this morning, but it's Buller at first instance. We can see what actually.
Have you got copies now?
I do.
And Mr. Shaw already has this, yes?
He does, yes.
Thank you very much.
Now, most of this is entirely irrelevant to the point I want to make. The judge gives a very long judgment where he goes through the history. And after refusing the main ground of relief that was sought by the claimants, one sees it's page 46 of 47. It's paragraph 301 to 303. There's a little section that says other relief. And His Honour Judge Berrin says, I've thus refused the two primary forms of relief sought by the Group B shareholders. And then he says, on the other hand, I found unfairly prejudicial conduct in three respects. In respect of Musefield Group B shareholders have suffered some loss. Of course, I mean, I hasten to add there, I mean, it's slightly loose language because, of course, they were shareholders in a company and the wrong was alleged to have been done to the company, but leaving that to one side. He said, in respect of Whitehall Mill, which is the property, Indigis and, I don't want to attempt to say that, may have made profits as a result of the breach of fiduciary duty. And then he goes on to say at 302, I'm prepared to afford relief to the Group B shareholders in respect of those matters, either in the form of an inquiry as to loss or an account of profits. The precise form of the relief may have to be argued before me. I'm not prepared to grant any other form of relief. Now,
He didn't say what the third respect was either, did he? In 301?
No, he didn't. I think the important one, really, I think for present purposes, is the one that relates to the Whitehall Mill. But the point I'm making here is that in respect of what seems to have happened is that the judge reached, as it were, a tentative conclusion that some relief was warranted in respect of the breaches he'd identified. And then it looks like there was a further hearing, and unfortunately we don't have a judgment that arises out of that hearing. But what we end up with is an order of the kind that the court has seen, which ultimately goes off to the Court of Appeal. And we'll come on to the way Court of Appeal deals with it in a second. But we simply don't know why it was that this form of relief was ultimately ordered. I'm speculating, but one possibility might have been that effectively it was by consent, because you'll remember that obviously the company, the third party company, wasn't a party to the unfair prejudice petition, and it had to be I think what happened was that the advocate for the respondents agreed to constitute himself as counsel for the company for the purposes of enabling an order to be made against the company that it transfer the property over to the other company. So it looks like there might have been a degree of cooperation in the kind of making of that order, and obviously we don't know why. But one possibility is that the defendants to the unfair prejudice petition didn't have the money to pay the compensation that might otherwise have been ordered, or the account of profits, and that they agreed that the solution was that the company go over. I mean, again, I'm speculating, but the point I'm trying to make, I suppose, is that we simply don't have we don't know why that order was ultimately made. And in my submission, this is not a case really about knowing receipt. It's a case that was really an unfair prejudice petition and confined to the facts of that particular case. And so, in my submission, the judge in that case thought this was the fair way to remedy the prejudice, and it's easy to see why. The director shouldn't have used the opportunity for himself, but the company shouldn't receive the land for free. And in my submission, that outcome doesn't bear any resemblance to a claim in knowing receipt, because claims in knowing receipt don't, for example, require a price to be paid for the transfer of the property. You're saying, as it were, touching on what we discussed earlier, that's mine. Now, that's the context for the Court of Appeal's decision, and the primary focus of the Court of Appeal's judgment in Buller was concerned with the question as to whether the fiduciary was labouring under a conflict of interest and therefore acted in breach of duty. So what had happened was that the respondents had appealed the judge's order on the basis that the argument they were making on appeal was that there was no breach of duty, by the fiduciary because it was as it were, it wasn't property that the company ever owned. So that was the focus of the argument. It wasn't really focused on the remedy, and we see that if we go to paragraph 20 to 23. This is page 46. Mr. Barragan is attractively presented submissions, submits the director of the company is under no duty to offer to the company business opportunities which come to him privately, notwithstanding that the company may be in a position to exploit such opportunities. He then goes on, and one sees then at the conclusion at paragraph 23, Mr. Barragan submits the judge's finding that the opportunity to acquire the property was not a maturing business opportunity is sufficient in itself to dispose of the claim based on breach of fiduciary duty, and that no question arises as to possible conflict of interest. He submits that on the facts, as found, the appellant's actions in pursuing the property through Silvercrest were not related to the company's affairs, nor can they be said to have been done in the course of managing the company's affairs, or to have been involved in utilisation of opportunities or special knowledge as acquired by directors. And then, if you go forward to paragraph 27 over the page 427, one again sees Lord Justice Jonathan Parker dealing effectively with the submission that there was no breach of duty. And of course, the focus here was on the fiduciary himself. It wasn't really on the way that the remedy or the liability, if you like, of any third party. And one sees that, I don't need to read it out, paragraphs 27 and 28. And then going further on in Lord Justice Jonathan Parker's judgment, at page 430, one sees the conclusions at 41 and 42. And again, it's a similar point. The focus of the judgment there was about whether this constituted a breach of duty. And importantly, in this context, the focus was on what the position of the fiduciary was, rather than on the position of the third party.
It's traditional conflict of duty and personal interest in relation to a trustee, a director, a person who owes duty to a fiduciary, and it's the very old and well-known cases. Absolutely.
And that's all the appeal was concerned with, and it was sufficient to dismiss the appeal, because the appeal was only really about whether that question was correctly decided by the judge. It had really nothing to do with the remedy, because it effectively seems to be the case that the respondent wasn't seeking to, as it were, overturn that on an independent ground. It was more that the finding of breach was wrong. That's what they were contending. So in my submission, Buller doesn't help my learned friend at all, and it's certainly not an authority for the proposition that no pre-existing trust property is required for a claim in knowing receipt. And I say that particularly when set against all of the other authorities, not least Buyers. My learned friend only referred to one other case in the course of his oral submissions, which was the case of Cook and Deeks. Now, that case, it's again, it might just be worth turning that up. It's in Authorities Bundle 1, so where you are at tab 3. And it's page, the report starts at page 20. And again, in my submission, and I won't take you back to the judgment, but the judge correctly analysed this case, and that the reference for your note to that is at paragraphs 243 to 245 of the judgment, of the quantum judgment, and that's page bundle 1, tab 17, page 338. The judge correctly noted that this was a case where the fiduciary took advantage of the opportunity and then afterwards transferred a tangible asset in the form of contract to a third party. Now, in my respectful submission, we don't need to see how other judges have described this case, such as how Lord Justice Lewison described this case in FHR, as my learned friend did. In my submission, the inquiry begins and ends with the judgment itself. And one can get, as my Lady Justice Asplin pointed out, simply by reading the head note. Once he's at page 20, the 3 directors of a company carrying on business of a railway obtained a contract in their own names to the exclusion of the company. The contract was obtained under circumstances which amounted to a breach of duty by the directors, constituted them trustees for its benefit on behalf of the company. And then, so one sees that was what initially happened. And then going over the page, or a few pages over, page 26, in fact, I don't think we need to dwell on this. My learned friend took you to this yesterday, and one sees the way it was described as the defendants became certain of their position and knew that they'd obtained the contract for themselves. They then, for the first time, informed the plaintiff of what happened, so they fessed up, as it were, to their principal. He protested without result. And the defendant, Dominion Construction Company, was formed by the 3 defendants to carry out the work. The contract was accordingly taken over by this company, by whom the work was carried out and the profits made. So I say this was simply a different case which concerned receipt of the property by the fiduciary first, and then it's transferred to a third party. It's not a case in my submission where a third party acquired the property directly. I mean, I'd add that it's not even clear that this is a case of knowing receipt at all. It doesn't really seem to be described that way in the report itself. And I think that we looked yesterday at what Lord Justice Lewison said in the FHR case about effectively what his lordship was saying there was, well, it must have been a knowing receipt because effectively he couldn't see any other way in which the company would be liable. But I mean, that being said, with respect to his lordship, I mean, the conclusion is equally consistent with the company being considered a nominee of the fiduciaries. The problem is it just isn't closely analysed in this decision. So, in conclusion, the best my learned friend can really do in his submissions on Cook and Deeks is to say, well, it isn't really clear, but on one, I submit, strained reading of this Privy Council case, decided in 1916, that an entire principle springs forth about knowing receipt of third parties. And in my respectful submission, it's authority for no such thing. My learned friend made another point, which was that if I was correct, that it would lead to an unattractive result because a claimant would be denied an effective remedy and where a company received the outcome of an opportunity. In fact, I think he went further in his oral introduction and said that the quantum judgment was good news for dishonest directors. In my submission, it's not correct at all. As my learned friend anticipated, my first answer is the company will always have a remedy against the defaulting director. And I say, parenthetically, by way of example, an account of profits can be fashioned in such a way as to measure the defendant's profit through the increased dividend or share value in an entity in which he has an interest. And I say that the Gwenby Valley case, which we haven't been to yet, but we will later, and I don't think it's necessary to turn it up, but it's an example of this in action. That's paragraph 137 of Gwenby Valley. On the other hand, if the company is interposed purely to defeat a right which would otherwise arise against the company's principal, that the court can pierce the veil or as we discussed, treat the company as a mere nominee of the defaulting director. And as I submitted, this didn't happen in the present case. Here, the quantum judge held, as a matter of fact, that there was no evidence that GBRK was used for those purposes by Mr. Monks. That was in the context of the Ashford site, and I'll just give you the reference without needing to turn this up. It's paragraph 267 of the quantum judgment, and the page reference is bundle 1, tab 17, at page 351. And you know, of course, there may even be other causes of action against the third party. One could imagine unlawful means conspiracy. I mean, there are all manner of different ways in which you might capture them on appropriate facts, but all is going to depend on the facts of the individual case. I know in this context, and it's going to be increasingly important later, that it's completely conventional for the court to treat third parties differently from fiduciaries. The first aspect of this is that a knowing recipient is not subject to the no profit and no conflict rules that a fiduciary is, because the third party doesn't owe the principal any fiduciary duties. It's for this reason that a knowing recipient isn't liable for merely receiving an unauthorised benefit from the misuse of trust assets. And of course, Keach and Sanford is obviously a different case dealing with a different situation. It's a strict rule which applies only to fiduciaries. The second aspect of this is that a knowing recipient is not themselves a trustee in the truest sense, because what happens is equity intervenes against a knowing recipient to impose a constructive trust because of the prior misapplication of trust property. And I think it's necessary to look at what Lord Sumption says in the Williams and Central Bank of Nigeria case. And that's in Authorities Bundle 3. Authorities Bundle 3, tab 45. Tab 45 and page 1714.
1714.
1714. Forgive me, the report starts at 1706. It's not necessary to dwell on the fact, but I just wanted to take you to what Lord Sumption says at 1714, paragraph 9. I just invite the court to read that paragraph and it goes over the page. So Lord Sumption there emphasising the fundamental distinction between a fiduciary or the trustee and the third party. So in my submission, none of this is unsatisfactory. It is just the correct application of orthodox principles. So in my submission, this ground of appeal should also be dismissed. I just note that, so the court is aware of how my learned friend's appeal works. Even if he was successful on this ground, i.e. the judge was considered to have erred as a matter of law, he'd also have to be successful on both grounds A, which seeks to expand the findings of breach, and ground E, which concerns the judge's refusal to grant an account of profits against GBRK in any event as a matter of discretion. So that's how it links together. Again, unless there were any further questions from the court, that was what I was going to say on ground B.
No, thank you.
So ground C. Now this is about the knowing receipt of the 21,000. Now what Mr. Davies relies on here is the statement of our expert witness, Mr. Hayward Crouch. I mean, the court was shown it yesterday, so I won't necessarily ask the court to turn it up, but what he said was, just to remind the court, he analysed, you'll recall there was a table in his report, and he'd gone through meticulously all the bank statements of GBR and had arranged them by date, and of course this 21,000 is, as it were, the only cash withdrawn in the second period. So we're in that territory, and he says it appears likely that the 21,000 received from May to August 2011 was withdrawn and or utilised for the benefit of GBRK. So my learned friend asserts that the Court of Appeal should now find that GBRK was liable in knowing receipt for that 21,000. Well, in my submission, that should be rejected for 4 reasons. Firstly, it's simply not open to Mr. Davies to seek to litigate this point by way of an appeal now. The court may recall the bank statements that my learned friend showed you yesterday. The narrative in respect of the withdrawals all say things like withdrawn, our monks, repayment fuel, etc. And just for the court's note, the reference to where those can be found is at Bundle 3, tab 19, page 262 to 264. One sees a number of transactions with narratives of that ilk, and from the documents one can infer that the money was obviously withdrawn, but we don't know what happened next. As an aside, I'd note that if you add up the amounts in the bank statements where the references I've given you to, they come to 18,000 and not 21,000. I don't know why that is. But in my submission, in a sense, it's a further difficulty with this court dealing with...
I think on the previous page you can make it add up to 21,000.
I see.
There is an entry.
I must have missed one then.
Yeah.
But yes. But my point really still stands. It's about the position of this court being in to make these findings. But on my first submission about whether it's open to Mr. Davies, he's been aware of these withdrawals since no later than September 2018, when he filed a witness statement, which was in opposition to our application for security for costs. Because he pointed to these withdrawals as having been made, and he's had the bank statements at the very least since our disclosure. Notwithstanding this, no case in respect of these withdrawals was advanced before either the liability judge, and he made no findings in respect of that. And this is really why Mr. Davies needs to succeed on ground A, because what he requires now is another finding and not of liability not found by the liability judge. So I say it's simply not open to take this point on appeal. Secondly, and in any event, as the court remarked during the course of my learned friend's submissions, the facts which underpin this ground are disputed. And are certainly not clear from the evidence that he showed you. Mr. Hayward Crouch's report is not definitive evidence of a knowing receipt by GBRK. It simply posits that the sums were withdrawn and or utilised. Well, it doesn't posit that they were. He said that it's likely that they were. So even Mr. Hayward Crouch couldn't be certain as to what they were used for. And I should say that my learned friend said during the course of his submissions to you yesterday that he cross-examined Mr. Hayward Crouch on this. That's true. The relevant part of the transcript isn't in the bundle for the court. And obviously, I can procure that's put in if you need it. But the long and short of it is that my learned friend actually invited Mr. Hayward Crouch to accept that all payments from the account from January 2011 onwards were for the purposes of GBRK's business. And Mr. Hayward Crouch, as one would expect, said he could not confirm anything of the sort. So he went no further than effectively he went in his report. And moreover, Mr. Monk's oral evidence, so Mr. Monk's was also cross-examined on this point, and he denied that the sum was used for GBRK's benefit, and he said it was used to pay GBR's creditors. And again, I won't take you to that, but the reference for your note as to where that is in the transcript, it's bundle 3, tab 24, page 276. And one sees that piece of evidence. Now, of course, another friend says, well, you shouldn't treat that as worth the paper it's written on. But the real point here is there's been no finding made in respect to that evidence. And to invite the court to make a finding of knowing receipt now, Mr. Davies must invite this court to make a new finding of fact. And in my submission, that would be wholly inappropriate. The third point is...
Sorry, just before you go on, you mentioned, I think, that the cross-examination of Mr. Hayward Crouch is not in the bundles.
Some of it is.
Some of it is.
This bit isn't.
Well, okay. I mean, could we be supplied with the relevant bit at some point?
Certainly. It really is just one page.
Yes.
Will you be able to get that over the short adjournment?
Yes.
Thank you.
My third point is that...
I'm sorry, I lost your second then.
I'm so sorry.
Where did the second start?
The second was effectively that...
The cross-examination point.
It was not definitive evidence. From
well,
Hayward Crouch.
the evidential picture... The first point is not open. Second point is the evidential picture isn't clear.
Okay, that's fine.
That's
Thank
the
you.
heading. And within that, obviously, there are a number of subpoints. But the third point is that even if the 21,000 had been used for GBRK's benefit, which is the highest really it can be put, even on Mr. Hayward Crouch's evidence, and it wouldn't be enough for a claiming known receipt because of bias. In my submission, we're in the territory of receipt of benefit. It's the highest my learned friend can put it, even conceptually. And Byers makes it clear in the passage that I took you to earlier that it isn't enough. Really, the third point is the short answer to this ground of appeal. The fourth point is that even if GBRK was in theory liable in knowing receipt for that sum, any such award would need to be set off against the judge's existing award of equitable compensation against Mr. Monk's to avoid double recovery. So in my submission, any order requiring GBRK to be jointly liable for that sum would be pointless. The equitable compensation award has already been paid by Mr. Monk's, either to Mr. Davies or into court. So there is simply no point in holding GBRK liable for such notional further sum. So unless there were any further questions on that ground, that was all I was going to say.
Thank you.
Ground D. Now that's the Ashford site. Now, this is, I respectfully submit, a very confusing part of the appeal. So what I suggest the court does is that it takes up the chronology set out in my skeleton argument, paragraph 66. It's bundle 1, tab 7, page 74.
I was just asking if anyone needs a short break. We don't, but if anybody does, it would be
Perhaps
short.
I could ask euphemistically for a brief one for the bar.
Yes, of course. So is 5 minutes enough? 5 to 10 minutes if we come back at 22?
Yes, of course.
Yeah.
Fine by me.
All right. Just before you get stuck in.
Okay. We could also just simply ask for the hard copy to be supplied because that's now. Yeah, maybe. We just need, there's just one page, I think. Oh yes, that was for me.
Brian's email onto another address.
Oh, thank you.
We've had another present.
Yes, I felt it was less disruptive to get it to you in that way.
Okay.
This is something I'm going to refer you to in the context of equitable compensation. So we're not there yet.
So ground D.
Yes, indeed, ground D. So I just was inviting you to take up my skeleton, which is the sort of perhaps the easiest way to follow the chronology. And my own friend did take you through this as well, but just to refresh your memory, because it's sometimes quite difficult to hold all of these transactions in one's head.
So paragraph 66, sorry.
Sorry, I was just going to say exactly that. I'm sorry to interrupt. It's paragraph 66.
Yes, exactly. So these are the sort of key events, and I'll just briefly run through them. So the first lease was taken by GBRK of the Ashford site prior to the 17th of March 2011. That was in breach of fiduciary duty by Mr. Monks, but it was received prior to the 22nd of May 2011, so a claim in no receipt must fail if for no other reason that it's time barred. I'd also add, of course, that the first lease has now expired, but nothing turns on that particularly. On the 23rd of June 2011, the freehold interest in the Ashford site was sold to Benchmark. So what had happened was that the owner of the site, which wasn't GBR, it was a company called Greenbox Assets Limited, or GAL as it's abbreviated to, owned the freehold of the Ashford site. And basically the Barclays, the lenders, who you'll recall, there's a point about whether Barclays had granted their consent for the grant of the first lease, but they appointed receivers over GAL for the purposes of realising their interest as mortgagee over the Ashford site. So it was sold as part of an arm's length transaction for value to Benchmark, which is a completely independent third party. Benchmark in turn granted a 10-year lease to Mr. Monks, subject to the first lease, which has been called the second lease. That was on the 23rd of June 2011, so this is within the second period. Obviously, Mr. Monks took that lease in his own name. On the 24th of November 2015, so this was obviously after the dissolution of GBR in October 2011, Mr. Monks assigned the second lease to another company called Greenbox Resources Limited, and on the same day, Greenbox Resources Limited entered into a lease extension, or I think it was described below as a reversionary lease, and the third lease was due to begin on the 30th of November 2017, which was the day after the termination of the second lease, and to terminate in 2025. And then finally, in the chronology, almost 9 months or so later, GBRK purchased the freehold from Benchmark, and when it did, GRL surrendered both the second and third leases. So those are the transactions that took place. And I should also add, because one of the points my learned friends made, I think, in the course of his submissions, was that the leasehold interest in the Ashford site was, as it were, had been obtained for free. But that isn't right. That value was paid, or a market rent was paid for all of these transactions, either an acquisition or a lease. Market rent was paid pursuant to those property rights throughout by the relevant entity that held them. Now, Mr. Davies is seeking, I think, two alternative declarations under this ground of appeal. The first is that the freehold of the Ashford site is held for GBR's benefit. And I think in the alternative, although he didn't pursue this orally, he says that the estate and land created by the third lease continues to exist for GBR's benefit. And of course, the third lease, had it ever taken effect, would have run till 2025, which may be why he's talking about the third lease. But I'll deal with each of them in turn. So firstly, his claim in respect to the freehold of the Ashford site. Now, before we sort of get into the detail, it's important to bear in mind that the only property that GBRK ever actually received in this whole period was firstly the first lease at some point prior to March 2011, and the second was in 2016 when it acquired the freehold of the Ashford site. So my submission that those are the only two pieces of property that GBRK ever actually received. Now, there are a number of problems with Mr. Davies' claims under this ground, but the fundamental problem he faces in seeking a proprietary claim over the freehold is in respect of timing. As far as the first lease is concerned, that lease is time barred, as we saw, and in any event has elapsed. And as far as the freehold is concerned, he can't seek to establish a knowing receipt claim for that because, firstly, the freehold wasn't trust property in the hands of GBR, or for that matter, Mr. Monks. It was owned at the time of the acquisition by GBRK by Benchmark, an independent third party from whom GBRK acquired it for market value, or I think even on the quantum judge's finding, over market value. That's the first problem. The second problem is that Mr. Monks didn't divert any opportunity to acquire that property from GBR in breach of duty. Mr. Monks, as at the date of the transaction when GBRK acquired the freehold, owed no duties to GBR because it had been dissolved. And the court will remember from what I took you to earlier, the decision in Courtwood Holdings, which provides that the transaction pursuant to which the alleged knowing recipient receives the property must itself be a breach of trust. And again, I won't take you to the Courtwood case, but for your notes, that can be found in Authorities Bundle 3 at page 1975. And the relevant paragraph is paragraph 190. So, in an attempt to get round these, what I say are insuperable difficulties, my learned friend has come up with a string of, in my submission, complicated and ultimately incorrect arguments to try to establish the proprietary claim. And they're all based on fictions which either require this court to assume events have occurred which haven't occurred, or they require the court to treat several corporate entities as synonymous with Mr. Monks. Some of those corporate entities aren't even parties to these proceedings. And it requires the court to make additional findings of liability, including those against those non-parties. So, turning to my learned friend's, he puts his case in two ways. Turning to his primary case, and what that is he says that GBRK received the benefit of secured occupation of the Ashford site when Mr. Monks entered into the second lease on the 23rd of June 2011. And what's going on here, really, is that my learned friend's trying to find a way in which he can put property being received by GBRK in the limitation within the sort of narrow window that he's got to avoid the claim being time barred. So he's fastened upon the transaction whereby Mr. Monks took the second lease in his own name. And he says that that secured for GBRK the benefit of the occupation of the Ashford site. And the short answer to that point is that even if, which I don't accept, GBRK acquired the benefit of secured occupation of the site as at that date, that's insufficient as a matter of law to found a claim in knowing receipt. Again, that's what the judge actually found in below at paragraph 260 of his judgment. He found that, as it were, as a matter of the principles that we've been debating in the case, but it's since been confirmed as good law by Byers. So it's the same buyer's point. It's about benefits rather than property. And so in my submission, that's simply the end of the first way in which my learned friend puts the case for a proprietary claim. In any event, I mean, the logic of my learned friend's case is simply wrong on this. As the quantum judge himself held, GBRK didn't even receive any marginal benefit from the grant of the second lease to Mr. Monks. It already had the first lease, which gave it the rights which it had to occupy the site. And the real point is this: those rights were only truly secured in any kind of conceptual sense once the freehold had been acquired by benchmark from Gal's receivers. Of course, the point my learned friend makes is that the lease was unsecure because Barclays hadn't granted its consent for Gal to grant the lease. But that state of affairs was only remedied once the receivers sold the freehold to benchmark. And that, in my submission, has nothing to do with the second lease.
But even then, the new freeholder could have, I suppose, complained about that lease, or not. No, that's not right.
I wouldn't have thought. Well,
No. Sorry.
They also knew about it. I mean, it's quite clear that, in fact, Benchmark was the grantor of that lease, of the second lease. Are you talking about the first lease?
No, I'm fine. It's all right. Thank you.
But in any
it rather
event,
begs the question, Mr. Cook, though, as to why Mr. Monk took the second lease.
well, I mean, I'm not sure I can particularly help the court with that. I mean, I don't want to, I don't want to, as it were, extemporise what the evidence said on this on my feet. I want to sort of
Can you just direct us to how the judge dealt with that?
Yes,
He
so
may not have asked the question, but it just seems that it was if there was no benefit to be had by getting the second, but I mean, you've answered the point. A benefit isn't good enough anyway.
Yes.
But it seems a bit of belt and braces, doesn't it?
I may have misunderstood this. I thought the point was that the second lease was, so to speak, in a stronger position than the first one because it didn't involve the problem about the lack of consent from the mortgagee. So that even if the first lease was forfeited, Mr. Monks personally still had the benefit of the second lease.
yes.
So why was that not? And I think the judge found, or at least accepted evidence, that the whole purpose of the exercise was to put the occupation of the site on a more secure footing.
Well,
What's
I mean,
wrong with that?
that may or may not have been the rationale. And my key point, and perhaps this goes to some of the discussion yesterday about the interrelationship between the first and the second lease. I think my lord was interested in the answer.
The landlord aspect of it.
Yes. The landlord aspect.
Yeah.
I mean, I suppose what I'd say about all of that, I mean, I should say we've done some preliminary research overnight, but I'm not quite sure I'm confident to be able to give you a...
Well, I've done a little bit, but I got no further. Maybe one doesn't need to go further than Macur and Wade, which has a useful couple of pages on leases of the reversion operating concurrently with an existing lease.
Yes. I mean, interesting how this debate is. I mean, my
May all be
submission...
completely irrelevant.
My submission is that it's completely irrelevant. It doesn't matter. My point is, GBRK didn't receive any property.
Yeah.
However one cuts it, as at the 23rd of June. I'm sorry, Melody, I may not have actually really dealt with your...
Well, you
knowledge.
probably have. You've probably said, well, I can speculate, but it doesn't matter.
Ultimately-
Whatever he thought, it doesn't matter. But,
Yes. My
There
point
we
is,
go.
my point, I suppose, is, it's GBRK didn't receive any property at all during the second period. And insofar as, which I don't accept, it received a benefit, it's not good enough.
no, I understand that.
Just briefly, again, it's a sort of second aspect of why the logic in my learned friend's case just simply doesn't work. Even if GBRK was considered to have enjoyed this alleged benefit, it's unclear why it should hold the freehold reversion on trust for GBR. Now this is sort of getting us into waters where my learned friend effectively says that he applies Keach and Sanford to a situation where at best you've got a sort of theoretical knowing recipient, and then he sort of suggests that that knowing recipient can't, as it were, acquire the freehold. So he blurs the distinction between the position the fiduciary is in, which would be subject to Keach and Sanford, and the position which a third party is in. And in this regard, I think he relies in his skeleton on Prothero and Prothero, and I think orally he took you to a passage in that which was quoted in the Thompson trustee case, which we'll come on to look at. But all of those are authorities for the proposition that a fiduciary, which owns a leasehold interest, not, I would add, a benefit, it can't purchase the freehold without consent from their principal. I don't think we need to go to Prothero, but that's the proposition that authority establishes. And here, neither GBRK nor GRL are fiduciaries. So the reasoning simply doesn't apply. I mean, I'm assuming, of course, against myself, which I also don't accept, that they are even any kind of constructive trustee. But even if they had been, it wouldn't work.
Sorry, you said neither GBRK nor, what was the other one?
Sorry, GRL, and that's
GRL.
Yeah, that's the company that
Yes.
was the assignee of Mr. Monks's interest in the second lease. So
Sorry, I'm getting my company.
Yes, I'm so sorry. Perhaps go
No,
back.
GRL. Sorry,
So GRL, yes.
GRL. Yes.
Back to my skeleton at 66.
Yep. Thank you.
But yeah, so what happened was GRL it did two things. It received an assignment of Mr. Monks's interest in the second lease. I think that was in 2015.
Yes.
And it also entered into the third lease.
Yep. Sorry, and GRL is a Monk's company. It's one in which he has a 50% interest.
Yes. So, but we were dealing with. Well, there are several corporate entities here,
Yes.
and the key point here is that neither GBRK nor GRL are fiduciaries.
Yeah.
The fiduciary here is Mr. Monks.
Yes.
So, again, I say that all of that reasoning, the sort of Keach and Sanford, the Prothero and Prothero, all of that reasoning of those cases is not one that is applicable to a non-fiduciary, such as the corporate entities. And I mean, there's a sort of additional point here, which is that nobody on any view could owe any duties to GBR in 2016 when GBRK acquired the freehold, because it didn't exist. So even if, as it were, I was wrong about that, one has to establish the knowing receipt claim, one has to, the transfer has to be in breach of trust. So that was what I was going to say on my own friend's sort of first way of putting the case. Short answer is buyers, and then there are a number of other points I make, but really the short answer is buyers. Moving on to his alternative case, I think that the way he puts it there is in relation to GRL, or I think he says it's based on Mr. Monks being a trustee of the second lease, or holding the second lease on trust for GBR. So here the court will recall what happened was during the second period, Mr. Monks acquired the second lease, and that was found to be in breach of duty. So Mr. Holland found that he held that on trust for GBR. And then, of course, what he did was in 2015, he assigned that lease to GRL. And what my learned friend says is that if GRL had purchased the freehold interest in the Ashford site in 2016, it would have held that property on trust for GBR. So effectively what he's saying is that GRL would have been in a Keach and Sanford situation where it was disabled from acquiring the freehold interest in the Ashford site. So that's sort of proposition one, or building block one of my own friend's argument. And then building block two is a sort of shift to say, well, you can't sort of get around it all by GBRK having done it. So he says, when GBRK acquired the freehold interest, it must also have held the property on trust for GBR. And then I think he says this, I'm quoting from his skeleton, paragraph 85, because Mr. Monks cannot evade Keach and Sanford by interposing another corporate vehicle. So again, we see another switch. The way of analysing it there is sort of we're now concerned with Mr. Monks to acquire fiduciary. So there's been a shift from looking at the liability of GBRK in knowing receipt to considering a sort of global analysis based on Mr. Monks trying to get around Keach and Sanford. So it's sort of all over the place. And in my submission, there's a real air of unreality about this submission. My learned friend's postulating a set of events which didn't occur. Now, proprietary claims, as the court knows, are meant to be concerned with the application of clear legal rules of tracing and such like. They aren't concerned with hypothetical turns of events, as this argument is. But in any event, neither of the two propositions is correct, and I'm going to come to deal with each in turn. So turning to the first proposition my own friend makes, in other words, that GRL would have held the freehold on trust. Again, and I don't want to repeat myself, I've already dealt with this briefly already. It assumes that GRL is in a position of, in a fiduciary position vis-a-vis GBR. In my submission, that's wrong. Even if GRL held the second lease on trust for GBR, so even if it was the case that it did, because it was impressed with a constructive trust when it took the assignment of the second lease from Mr. Monks, it does not and never did owe any fiduciary duties to GBR. And the court will recall, I took the court to the Williams Central Bank of Nigeria case. You recall the passage by Lord Sumption in that case. A recipient of this kind is simply not subject to the no profit and no conflict rules that are applied to a fiduciary. So my submission is that had GRL actually gone on to purchase the freehold, of course none of this happened, but had GRL gone on to purchase the freehold on the 1st of July 2016 instead of GBRK, it would not, in my submission, have held the freehold on trust by virtue of the rule in Keach and Sanford. That, of course, is a case where the fiduciary himself held the lease on trust, and the transaction was a further breach of the no conflict rule. Now, my learned friend referred to the Thompson's trustee case, and I think he said that the case was authority for the proposition that Keach and Sanford somehow applied to a company that was owned by the fiduciary. I think he's suggesting that's somehow a general proposition, but I don't accept that. If we just go to the Thompson's trustee case, it's at Authorities Bundle 1, tab 8. Bundle 1, tab 8, at page 109. And what had happened was that this was a case where there'd been a dissolution of a partnership, but property was acquired, held to be in breach of the duties owed within that partnership. And one sees at page 109, internal page 612F, the court discusses it, having cited the Prothero case. My learned friend took you to this yesterday, but I'd invite you to go on to read. It says, it seems to me, however, that apart from the fact that it binds me, this decision, like the rule in Keach and Sanford, is really in modern terms an application of the broad principle that a trustee must not make a profit out of the trust estate. This principle applies to all kinds of collateral advantages, for instance, directed remuneration received by a trustee acting as a director for a company controlled through the shares of a trust. So we're concerned with the rule in Keach applying only to the fiduciary and the collateral advantages obtained by the fiduciary through the breach of trust. And in this case, what happened was there was a company that acquired the property, and it was made to account for the profits, but together, as it were, with the trustee, the fiduciary. But what seems to have happened in this case is that it seems to have been conceded that the company was not in any better position than the fiduciary himself. And one sees that if one goes to page 613, internal 613, at G. And it's really, I just invite the court to read the highlighted paragraph there, page 110. And so it doesn't seem to have ever been an issue in that case. It's rather one where they're all treated as one and the same. And one sees, if you go back to page 102, the head note of the case, one sees the relief that it's actually in the sub part of the held part of the head note. And it's after the semicolon, about halfway through that since T had never refused to participate in the sale, the executors of H or H's company became accountable to T for a half interest in the freehold reversion, and accordingly they are accountable for one half of the net proceeds of sale of the freehold. So in my submission, it's a case where effectively it was conceded and or the court proceeded on the assumption there was no difference for the purposes of analysing it between the fiduciary and their vehicle. But the analysis as to the application of the rule in Keach and Sanford is one that's squarely focused on the fiduciary himself. So that's the first limb of Malone and Friends. The first part of Malone and Friends' proposition, and the second proposition is that it involves a further hypothetical leap to say that because GRL couldn't have acquired the freehold, GBRK, which is obviously a different company, also can't do so and allow Mr. Monks to escape the application of the Keach and Sanford self-dealing rule. Well, again, it's difficult to know where to begin with this submission. Firstly, it's postulating a series of events which didn't happen. Secondly, the approach completely seeks to align together Mr. Monks with GRL and GBRK. And it seemingly invites this court to pierce the veil, despite the fact that such a case wasn't pleaded or advanced below. And in any event, the quantum judge specifically found that the freehold was not acquired by GBRK, specifically to avoid liability on the part of either GRL or Mr. Monks personally.
Could you just say that again, Mr. Cook?
Yes.
from my note.
The-
The last part. what
Yeah,
you
sorry.
said.
So the quantum judge, he expressly found in this context that the freehold wasn't acquired by GBRK, specifically to avoid liability on the part of either GRL or Mr. Monks. And I think I gave the court the reference to that, but I'll do it again for your note. It's paragraph 267 of the quantum judgment. And that's the bundle reference for that is bundle 1, tab 17, page 351. Now, of course, and that finding I add is not appealed. The other point that's important to bear in mind is that with the sort of analysis of it from the perspective of Mr. Monks trying to evade Keach and Sanford is that the court is concerned here with the liability of GBRK in knowing receipt. My learned friend can't get around the fact that the key requirements of such a cause of action simply cannot be satisfied in respect of GBRK's acquisition of the freehold, for the reasons I outlined at the start. So, in my submission, the judge was right to conclude that the requirement wasn't satisfied when GBRK acquired the freehold. Two reasons. Firstly, it was acquired from Benchmark, an independent third party, and secondly, it was at a time when GBR was long dissolved. The final point I'd make on my learned friend's alternative case is this. The judge was plainly right to hold, as a matter of law, that upon GRL's surrender of the second and third leases, those estates and lands ceased to exist as a matter of law. And my learned friend didn't really deal with any of this in his oral submissions, so I don't propose to dwell on it. But the cases are all cited in our skeleton argument and were dealt with by the judge. For the court's note that the cases in question for that proposition are Barrett and Morgan and Allen and Rochdale Borough Council. Just dealing with each of those in turn, Barrett and Morgan, the court can find that in Authorities Bundle 1, tab 21, at page 392. And in my submission, that case is clear authority of the proposition that the surrender of a lease results in the term being extinguished by operation of law. And then one has Allen and Rochdale Borough Council, Authorities Bundle 1, tab 22, and page 404. And in my submission, that case is directly on point in terms of my learned friend's argument. The relevant paragraphs are 14 to 17. And the basic position is that whether the property is knowingly destroyed or deliberately destroyed is irrelevant for a tracing claim. There is simply no substitution of a new asset for an old one. So the conclusion is that when GRL surrendered the second and third leases, they simply ceased to exist, and that there is nothing to assert a proprietary claim in respect of. Fourthly and finally, in respect of this ground, Mr. Davies has no answer to and doesn't appeal the judge's alternative finding that Mr. Davies would need to give credit for the sums expended to acquire the Ashford site, which would reduce the award by the same value. So what he was saying was that even if GBR, Mr. Davies as assignee, was entitled to the Ashford site, he would be required to give credit for the amount that GBRK had paid for it, which was 800,000 back in 2011. And one of the strange things is that the joint property expert valued the site at the same amount in 2021. So it doesn't seem to have increased in value in that period. But in any event, that's important when considering the practical consequences of a conclusion that, in Mr. Davies' favour, given the conclusion of the joint experts, he would have to return the 800,000 that, by coincidence, is also the amount that the judge awarded by way of equitable compensation against Mr. Monks. And so, were Mr. Davies to be afforded a proprietary claim over the Ashford site, he'd have to repay the 800,000 but would keep the site. And in circumstances where Mr. Davies, who resides in Dubai, has no possible use for the Ashford site, that can't, in my submission, have been a sensible outcome.
I think that's at 269, isn't it? The credit point.
269, yes.
Yes.
It's page 532 of bundle 1.
Sorry, 269 is in...
This is where the quantum judge deals with this point.
Oh, in the quantum judge.
Yes,
Yep,
so
thank you.
bundle 1, tab 17, page 352. So the only other point on this ground I want to just flag up is this alternative claim that somehow the third lease survives for the benefit of GBRK. I mean, my learned friend didn't deal with this orally at all. It's not difficult to see why. The short answer is it simply ceased to exist as a piece of property, which would in any sense be capable of being traced into or surviving for the benefit of GBR today. I've already made the submissions about the effect of a surrender as a matter of law, and that is the answer really to that alternative way of putting it, which doesn't seem to be seriously pursued in any event. So, unless the court had any further questions on ground D, those are going to be my submissions.
Thank you.
So ground E, this is about the account of profits. This is the appeal against the judge's discretionary decision to refuse to grant an account of profits against GBRK. And the easiest way to deal with this is to see how the judge dealt with it. If I could invite the court to take up bundle 1, tab 17, page 355.
Can you refer me in your skeleton argument to where you deal with ground E?
Ground E. Yes, I can. Just it starts at page 63. Against bundle 1, page 63.
Thank you. I have it.
We deal with it quite early on because, in a sense, it seems to us that if we're right about that, it disposes of a lot of the other grounds because, yes, really that is the relief sought against GBRK. It's ultimately the account of profits consequential upon knowing receipt. So we put it up front, as it were, in terms of the cascade. But yeah, as I said, I'm addressing it in the order of my learned friend Ed. So yes, sorry, going back to the judgment, paragraph 275, at page 355. I should say, in fact, it's probably worth picking up at 273 on the previous page. What the judge did was he reminded himself of the nature of the discretion he was exercising. Per Mr. Justice Lewis and his then was decision in Ultraframe, And perhaps it's worth actually this court just reading that quotation from His Lordship's judgment. So, and one sees, just picking up some of the highlights from my perspective, it's obviously an incredibly sensitive, fact-specific sort of analysis. And among the factors listed by Mr. Justice Lewis in here is it's important to establish exactly what has been acquired. Fashioning of an account should not be allowed to operate to the unjust enrichment of the claimant. And then, in some cases, I'm reading from the end of the quotation here, in some cases it may be appropriate to order the making of a payment representing the capital value of the advantage in question, either in place of or in addition to an account of profits. So, proportionality obviously is a multifaceted inquiry. And what the judge, having reminded himself of that, he then quoted various passages of the Novaship case, which I actually want to take the court to the decision itself in due course, but we'll come back to that. And then one sees at the bottom of page 355, paragraph 275, I decline to order an account of profits against GBRK. And then he essentially does this. For two reasons, although it's expressed at A, B, and C, in reality, A and B are the same point. And the reasons are, firstly, that the judge recognised that the granting of an account in this context against GBRK was, it required Mr. Davies to have established a claim in known receipt against GBRK. And he had held that GBRK was not liable in known receipt because its liability was limited to property received pursuant to breaches of trust found by the liability judge. And he concluded that there was no such property. He also rejected, one sees at B on page 356, he declined to hold that GBRK held the entirety of business on trust, GBR, as at the 18th of October, or indeed any other date. So he's rejecting, therefore, any notion of this formulation about the business, as it were, ever being held on trust. And again, I won't take you to it, but there's a section in Ultraframe where Mr. Justice Lewis then was effectively rejected the proposition that a business, as it were, can ever be held on trust. You're looking at the individual things that comprise that business in terms of actual property. So those were his findings, and effectively he said that Mr. Davies hasn't established known receipt at all, so there's basically nothing to grant an account in respect of. And he was plainly entitled to form that view. And so in terms of this appeal, this ground will fail automatically unless Mr. Davies also succeeds on ground A, the liability judgment, paragraph 272 point. And that's because no property was received pursuant to any of the breaches of duty found by the liability judge in paragraph 272. The only breaches of duty were found were those there, so no property was received by GBRK pursuant to those. And the second point, ground B falls way, because if it can't be established if ground B can't be established, my learned friend can't establish that any part of GBRK's business is held on trust for GBR, sorry. I'd add he also fails on ground D, which is the claim about the Ashford site, because if that can't be established, I'm sorry, I put that the wrong way. If he doesn't succeed on ground D, he also can't succeed on this, because if ground D can't be established, there's no property knowingly received in respect of which to order an account. So that in my submission deals with the first way in which the judge rejects the claim for an account. So that's A and B of paragraph 275. Subparagraph C on page 356 is a freestanding justification for refusing to grant the account. And in my submission, that would justify the judge's decision even if my learned friend was successful on any of the other grounds. And what the judge did was, in his discretion, he declined to award an account of profits because of the fact that he'd already concluded that Mr. Davies was only entitled to the value of GBR's business as at the end of, or as at the 18th of October 2011, and that effectively anything after that period, given that it couldn't have traded, simply has no connection with the wrong that was allegedly committed to GBR. Or another way of putting it, as I think the liability judge did, was that everything that happened thereafter, or it might have been the quantum judge, everything that happened thereafter was attributable to Mr. Monk's own efforts. In other words, after the cut-off point. So effectively, he was concluding that it was disproportionate on that ground as well to have an account of profits, which would in any event have to be set off against for the purposes of preventing double recovery, the award he'd already imposed against Mr. Monks. And in my submission, the judge was entitled to consider in that evaluation whether or not the wrongful acts of the third party had caused the relevant profits to be made. Also, as we've seen, disproportionality is an aspect. And one of the things that the judge also did is he referred back, obviously, to the discussion he'd had earlier, which we'll come on to later in terms of the ground on equitable compensation, but the Warner and Dwyer decision, the decision of the Australian court, where effectively what the court says is that there comes a point with any sort of breach of duty where the business that is carried on, it sort of ceases to be attributable to the earlier breach, and the court can draw a line and say, well, that's enough. And I think what what the quantum judge was doing was saying that he's drawn the line, and that also affects his discretion as to whether or not to order an account. I've made 3 points about the judge's decision in this regard. The first is that obviously it's a discretionary decision with which this court will be slow to interfere unless it's convinced that it's plainly wrong. I accept obviously it's a discretion that needs to be exercised on the basis of established principles, but in a sense there are a few areas of discretion which the court exercises which aren't to be exercised on the basis of established principles. And one sees what they were from the ultra-frame decision, which I took you to in the context of the judge's judgment. And the simple point is that the judge was best placed to make that determination in the circumstances of this case. And this court, in my respectful submission, is not in a position to second-guess the factors of which the judge had direct and intimate knowledge. And one of the things that my learned friend said in the course of his submissions was that I think my learned friend and I agree that proportionality is sort of the only touchstone. Well, it's not quite correct, because I think my learned friend several times in his submission suggested that causation was not something that came into the consideration as to whether or not to grant an account of profits. Now, of course, I accept that that is the case in respect of a fiduciary, but that is not the case as regards a third-party recipient. So what one sees in the cases, commentary to the effect of, one sometimes sees in account of profits cases that, well, it doesn't matter that the company couldn't have, or the principal couldn't have made the profit because that's not what account of profits is doing. But those cases are all concerned with situations where an account of profits is sought and obtained against the fiduciary. And one gets that proposition of law from the Novaship case, which I mentioned earlier and the judge quoted from. And it's worth us turning that up just briefly. That can be found in Authorities Bundle 3. It's tab 34. That can't be right. It's tab 44. Authorities Bundle 3, tab 44. And it begins at 662, but the passage I just wanted to take you to in respect to this area of the law is on page 1696.
Or is it 1698?
Well, we'll get there, but
Okay.
it's paragraph 107, which was the ultimate. Which was the paragraph, and perhaps it is best to take you back to paragraph 94, which is where the discussion starts. There's a subheading, it's page 1693. I'm not going to sort of take the court through all of this, but just to set the scene, causation. The question in this case was what's the causation? What's the relevance of causation when it comes to a third party or an accessory when an account of profits is being sought? And obviously, the first place that the Court of Appeal went to there was ultraframe, and then if I can sort of skip through, just taking along the way. In 1694, they referred to Regal and Hastings, and of course, that was a case where the fiduciary was in the firing line, and so that was sort of cited and dealt with by the Court of Appeal there. And then obviously we take a tour through various other authorities, including Target Holdings. We'll come back to that. And then paragraph 107. I just invite the court to read that paragraph.
I'm so sorry, which paragraph?
Sorry, paragraph 107.
107, thank you.
Yeah, 1696. Sorry, I'd invite you to go down to paragraph 109. And for completeness, I may as well show you because it is marked up. But obviously, 119. over the page at page 1698. Of course, the reason I didn't take you to that is it's simply just repeating the point that that it's a discretion. But the important point for the purposes of I'm saying at the moment is that the causation aspect is an important consideration. Therefore, the judge was entitled to take into account the fact that he'd concluded that GBR would no longer trade as at the October 2011. I mean, my learned friend, he says the judge was wrong to do that because it's well known that accounted profits ignores the question of what would have happened, whether the beneficiary could have taken advantage of the opportunity or whatever it is. But that's not correct when it comes to evaluating an account against a third party. Although I accept it is vis-a-vis an account against the principal. Sorry, the fiduciary. So, thirdly, and in any event, the judge's reasoning in this regard is in my submission, unimpeachable. Mr. Davies had, at this point, already received an award of £800,000 plus interest by way of equitable compensation to be paid by Mr. Monks, and that provided full compensation for GBR's loss. To make an additional award against GBRK would indeed be disproportionate. For the following reasons. Firstly, at its highest, Mr. Davies could only claim in respect of property that GBRK received in the 5 months of the second period. So even conceptually, that's the window we're talking about for any kind of knowing receipt claim. And the only breach of duty identified by the liability judge in the second period related to Mr. Monks's taking of the second lease for his benefit. So obviously the judge had made a number of findings about things that Mr. Monks did, but the vast majority of them, or all but one, fell within the first period, and the one that fell within the second period concerned a piece of property that Mr. Monks acquired in breach of duty. He acquired it himself, so it didn't go to GBRK. So that simply can't be the subject of the knowing receipt claim against GBRK. And the second point is this: even if the court were to go on some roving mission to find what assets were actually received by GBRK in the second period, the evidence shows that no or no material assets were acquired by GBRK during the second period, and the profits that might have been attributable to them were negligible. Now, the easiest way to illustrate this point is by reference to the summary in my skeleton argument, rather than taking you to all the detailed expert evidence. But sorry, you can put authorities bundle 3 away. If I could invite the court to take up my skeleton at it's bundle 1, tab 7, page 65. So, page 65, it's paragraph 36, where I summarise what Mr. Hayward Crouch, who was my expert, did. I would add that if the court's wondering why, well, put it this way, Mr. Hall didn't do this exercise. I would say, despite the terms of an order which were fought over fiercely as to what the experts would do, in the end, Mr. Hall didn't in fact attempt any such exercise, but my expert, Mr. Hayward Crouch, did. And he really had to scrape the barrel, if I can put it that way. So you see the summary there, and I did invite the court to just read that summary as to what he found, but I'd emphasise in particular the final sentence of that paragraph 36.4. So the point that Mr. Hayward Crouch makes at the end of, which is summarised at the end of 36.4, is that he concluded a negligible amount of GBRK's profits or value at any point in time could be attributed to the acquisition of the assets in the second period. And of course, there was no sort of contrary expert evidence, and this really wasn't examined as part of the trial at all in the end, because the case was simply advanced in a sort of different way by Mr. Davies. But that's the only real evidence we've got on it, and it's just vanishingly thin. And of course, as for I think one of my complaints my own friend makes is, well, this didn't consider, customer contracts and all that sort of stuff. I mean, of course, the court will recall that the liability judge, firstly concluded that GBR didn't have any goodwill or contracts of any value, but crucially also found that the nature of the waste management industry is incredibly sort of fickle and competitive, and he endorsed the colourful phrase that you're only as good as your last skip, as being a shorthand way of saying that basically it amounts to saying there's no such thing as goodwill in the waste management industry. Presumably it's just all about how competitive you are and good service you provide. So he endorsed that approach. So in my submission, there's not really anything in that point. So as a consequence, at first instance, Mr. Davies failed to identify any items of property or even opportunities that GBRK received in the second period, in respect of which an account could even be taken. And although my learned friend didn't make this point orally, in his skeleton, Mr. Davies says that he attempts to get around this point by suggesting that in the absence of a finding that GBRK was a valuable company at the end of the first period, therefore the entire value of GBRK's business at the end of the second period is attributable to assets received in the second period. So he sort of attempts to suggest that GBRK's growth was sort of zero until the second period, and then everything happened in that period. In my submission, this simply is a total non sequitur and should be rejected. The court can't assume that in the absence of a finding that it was a valuable company at the end of the first period, that all the value was generated during the second period. Moreover, to the extent that any profits had been made up until the end of the second period, that would be reflected in the valuation that Mr. Holland conducted of GBRK's value as at the end of October 2011.
I'm sorry, I'm going to have to ask you to say that again. I was slightly behind with my
Yes,
notes.
I'm so sorry. To the extent that any profits were made by GBRK as a result of anything that happened in the second period, that would all be reflected in the value of GBRK as at October 2011, which Quantum Judge valued and then ordered Mr. Monks to pay to Mr. Davies.
When I asked Mr. Shaw about that, he said, well, it wasn't valued on that basis. It was valued on the basis of Mr. Simmons saying, I'll give you 200,000 for a quarter share, which has got nothing to do with the profits.
Well, let's step back from the methodology of the valuation, because obviously that we're going to go into that in some detail in the cross appeal. But what the goal of the exercise, irrespective of the methodology, which we'll put to one side, the goal of the exercise was to value GBRK. So it was designed to give Mr. Davies what GBR would have had it been traded, as it were. If Mr. Monks had complied with his duty, what would have happened was, as at the point at which it was dissolved, GBR would have had a business worth X. That was the exercise that was going on. So, in a sense, sort of quite apart from exactly the methodology of the valuation, court knows I criticise the way the judge actually did it, but the exercise in terms of compensation was designed to put GBR in the position it would and should have been, if you like. Had he complied with his duties. So in a sense, there's no difference, or in terms of the equitable compensation. There's no difference between. Perhaps put it another way. Why should Mr. Davies been in a better position, through any means, than GBR would have been in had Mr. Monks complied with his duties? I suppose that's. Not sure. Does that answer my lady's question?
Well, it was the question I asked of Mr. Shaw that gave the answer that I've just indicated to you, and you've said, well, it is an answer, but it actually doesn't matter because the value is the value.
Yeah, I mean, effectively, yes. I don't want to sort of trespass into the areas we're going to discuss in the context of the cross appeal, but whatever the valuation methodology, the goal is value GBR K in order to put GBR in the position it should have been, basically.
So that if the judge was right, Mr. Simmons' offer must have incorporated an element of the profits that the company were actually making or likely to make, because he wouldn't have made a future, as it were, gamble otherwise.
Yeah, I mean, we'll examine the logic of it. The logic
right.
is...
I'm just trying to get to the bottom of it. I did ask yesterday, and...
I mean, the logic underpinning the transaction multiple methodology, if you like, that the judge adopted is that the putative purchaser of the shares has, as it were, an understanding about the true value of the company.
Yeah.
So that's...
So he would understand what the profits were, and if he was saying, well, they're sufficient for me to take a gamble at this, he's incorporated it into his offer.
Yes, I mean, that's the theory. Of course, I disagree.
We'll listen to that in due course.
So yes, I've already, I think, dealt with my learned friend's suggestion that the judge was wrong to consider that consider causation as an important factor in the exercise of his discretion. I've shown you novioship. My learned friend, I think, also in his skeleton criticised the judge's consideration of double recovery. But in my submission, it's absolutely crucial to the proportionality of requiring an account to be taken. Given that my learned friend accepts that he couldn't recover the same sums from GBRK and Mr. Monks, sort of one after the other, what this ground of appeal seems to amount to is a criticism that the judge didn't hold GBRK jointly and severally liable for the same sum as Mr. Monks. I mean, I hasten to add that that's on the assumption that it was justified to hold GBRK liable for anything, but when boiled down to its actual essentials, it seems to be a suggestion that, well, even if the judge was right about all of that, GBRK should have had a remedy that was coextensive with that of Mr. Monks and should be held jointly and severally liable. Well, in my submission, it was open to the judge to consider that it was disproportionate to hold GBRK and Mr. Monks jointly and severally liable in circumstances where the judge had before him ample evidence of Mr. Monks's means. This court won't really see it because it's sort of a part of the case that hasn't come to this court on appeal, but there was huge amounts of information about Mr. Monks's sort of financial position that was before the court for the liability trial, because of the way in which my learned friend put the case on equitable compensation as to what Mr. Monks had received. So there was enormous material that the judge had to consider that question. And of course, GBRK, let's not forget, is also a trading company with stakeholders who aren't just Mr. Monks. You know, there are employees and there are other shareholders of GBRK, and it was perfectly legitimate in my submission for the judge to weigh all of this in the balance when deciding, as it were, how it was all going to work. And of course, part of the difficulty is that presumably it would require an account to actually be taken, because nothing had really sort of, I mean, presumably there would have to have been another hearing to identify the actual assets in respect of which the account is being taken. So again, the court can't be criticised for thinking that's all totally disproportionate in the circumstances. And I also say it's very important that this court, we look at this in reality. I mean, this court is now in a position where it knows that Mr. Monks has been good for the money. So it's not even a case where one can say, well, there's some uncertainty about it. And I do submit this court can't ignore that fact when sort of deciding whether or not to overturn the judge's order. Just because the judge didn't know, in my submission, doesn't mean this court can't, as it were, found a refusal to interfere with the judge's exercise of his discretion based on what this court actually knows now. And Mr. Monks obviously has paid the full judgment sum either to Mr. Davies or into court. So, as it were, this court can see how pointless it is to impose joint and several liability even more clearly than the judge. Finally, Mr. Davies seems to indicate that the outcome of any such account will result in an award of the value of GBRK's business as at the 31st of December 2015. Now, obviously, the court will recall there was some discussion of that date yesterday and why it's been picked. Just my brief submissions on that and why I say it's just totally wrong and it really doesn't make a lot of sense. It's alleged to be justified on the basis that it's putting the parties in the position which they bargained for, I think is the phrase my learned friend uses. And I say that it's a very odd submission because it relates to an alleged agreement between Mr. Davies and Mr. Monks. At its highest, on my learned friend's case, it's alleged that there was sort of an agreement between Mr. Davies and Mr. Monks, to which GBRK wasn't even a party, and which was struck, or allegedly struck, before GBRK even existed. So, to put the sequence of events in the court's mind, the handover note, which is the sort of the high watermark of my learned friend's case on this, was given by Mr. Davies to Mr. Ford, as it were, at the start of the. Take a step back. Mr. Davies was about, his disqualification order was about to kick in, so he was effectively handing the business over to, among others, Mr. Ford, and he prepared a handover note. And so that was all, as it were, given and delivered at the start of the sort of period of Mr. Monks' involvement in the case. Obviously, GBRK was not in existence at that point. So it's sort of particularly odd that alleged agreement is said to have some sort of relevance to the scope of an account of profits against GBRK. I mean, it literally makes no sense at all.
But isn't that just because GBRK is considered to be the proxy for the value that GBR would have had?
Well, I'm not sure that's the point my learned friend is making.
I'm just wondering.
I think I interpret him to be saying that it's about putting the parties in the position that they bargained for. And it sort of rather begs the question, you know, who are the relevant parties for the purpose of this inquiry? So yes, I mean, I'm afraid I simply don't follow it. But in any event, it's disputed that Mr. Monks ever made any such agreement. The liability judge didn't conclude that they did, and one can see that if one goes. My learned friend took you to paragraph 101 of the liability judgment, which is in volume 1 at page 160. This is tab 16.
I'm going to get paragraph.
101.
Thank you.
And this is as high as the liability judge felt that he could put it, and he sort of, where he gets to is to say, I mean, Mr. Monk said he never saw the handover note. Notes that it was addressed to Mr. Ford, so I accept Mr. Monk's evidence on this point. He goes on to say this. That is not to say, however, he must have been completely ignorant of the matters reflected in the handover note, and it seems to me he must have been aware, at least in general terms, at least at a general level, of the plans referenced in the handover note, some of which related directly to him. So it's a sort of, the liability judge doesn't sort of suggest that there was a sort of meeting of minds between Mr. Davies and Mr. Monk. What he's saying is that at best that he may have been aware of what Mr. Davies had in mind for him, Mr. Monk's, in the running of this business, and that's really the highest he can put it. And I mean, later on, I do draw the court's attention to the fact that the liability judge expressly rejected an argument that Mr. Monk was in breach of his employment contract, which is at paragraphs 249 to 251 of the liability judgment. But really, I don't think we need to go to that. I simply place reliance on the way in which it's put at paragraph 101. And I'm aware of the time, obviously. I'm basically very nearly done on ground.
Well, I was pausing before saying, where are we? Because you did say they were brief submissions.
Yes. Yeah, forgive me, my lady.
So if we can get to an actual...
Yes, well, I've got one or two more points to make, but they'll take a minute.
All right, well, if they take a minute.
Yeah. So that's the situation on this agreement. And I'd also say it's particularly odd about this point is that it rather seems to concede, by my learned friend, that what would or should have happened is a factor that comes into play when deciding the scope and extent of an account of profits. So, in conclusion, in my submission, the judge was correct to exercise his discretion to decline to order an account. He simply had no evidence of any valuable assets or opportunities received by GBRK. Moreover, and crucially, he had no evidence that those assets or opportunities generated a profit in excess of the amount of equitable compensation that the judge had already awarded against Mr. Monks. And sorry, the final point is this. One of the points that my learned friend seemed to pray in aid of was in relation to the question as to whether it would be right for GBRK to be held jointly and severally liable, and was in relation to the question of costs. Now, I simply invite the court to disregard entirely that remark. I'm simply not in a position to address it for reasons which are obvious. So, that was subject to any questions. That was what I was going to say on ground E.
No questions, thank you. So, Mr. Cook, we've got to ground E.
F. I've just done ground E.
Yes, we've just finished ground E.
Yes.
Good. So, how long do you think you'll be this afternoon? I was going to aim to finish my submissions, and I think I'm well on course to, if not slightly ahead of schedule, to finish by 4 on the appeal. It may be that I'm significantly ahead of schedule and we'll finish before that. It seems as though you are if we're going on to F.
Yes, although F is quite a big one.
Yeah, okay. Okay, although you covered some of the ground.
Some of it, yeah.
Already. Yep. Okay.
I'll do my best.
All right, 2 o'clock then, please.